Hey folks, thanks for joining. This is your guide for smooth cross-border data transfers and global CBPRs. So before we kick off the main event, I thought it might be helpful to set a little table stakes. So I want to talk a little bit about what is personal data, who is a data subject, what is processing, and what's a transfer. Hopefully these definitions will kind of help to guide the conversation. So I won't read everything on the slide, don't worry. But in general, GDPR, which is a great benchmark, refers to personal data as any information related to an identified or identifiable person. I tried to include some TLDRs for folks who are skimming. Someone who is or can be identified through a subset of information in your possession or your company's possession. And practical note, in certain jurisdictions like California, additional concepts such as a household are included. You'll hear the term data subject or similar also referenced. As one example, it is the individual with whom the personal data relates. That's an EDPB or European Data Protection Board definition, or TLDR, a person you have identified and identifying information about. Next is what is data processing? Basically, I'll go with the TLDR because of the substance of that. But it's when you're taking someone else's personal data and doing something with it is really the high level. So whether you're hosting it, storing it, transmitting it, manipulating it. And manipulating it could be as simple as taking a photo and editing it. Next slide, please. And then finally, what is a data transfer? Any transfer of personal information which is undergoing processing or intended for processing after transfer to a third country or international org. TLDR, where you send or provide access to personal data to a third party that is not the data subject. So with that, Beatrice and Lupe, when do data transfers occur?
I think that's, do I start, Beatrice, and then you jump in at any moment if you want? So I think that we have mainly, a company is going to face data transfers in two mainly scenarios. One, when they are sharing data, for example, with vendors, with partners, with third parties outside of their organization that are providing services. For example, a typical example, someone that is providing cloud services, and then they will have also transfers of data between companies within the same group. So sometimes, we see that it's easier for companies to pick up which are the transfers that they have with third parties that they engage to provide services to them than the transfers that they have within the same group of companies. We need to bear in mind that under GDPR, the fact that companies transfer data internationally within the same group of companies is considered a data transfer. It's like if you were sharing data to anyone outside of your organization. So you need to map the data flows. You need to identify if you have any transfer restrictions in the exporting country, and you need to apply and implement a transfer mechanism, like if you were sharing data with any other third party outside of the organization.
Yeah, I was going to say very often. It's my answer to when do transfers occur. I totally agree with that summary. And for me, I think one of the more interesting aspects is I think often there's general misunderstanding because we use the word transfer. It feels very physical in nature, like I'm picking something up and I'm moving it somewhere else. But no one does stuff like that anymore in the era of the cloud. I hope everyone's looking up at the cloud right now. But so I think now it's a lot more focused on access, and I think you need to be very explicit in that conversation when internally working with and I'm going to assume technical teams, so like engineering or product or marketing teams. Like you need to really be explicit in defining those terms, because as an in-house privacy officer, the best you can do is go and ask people what they're doing, right? Like you're not going to be out there physically testing what they're doing most of the time. Most of us can't code. I know there's a lot of lawyers out there that can, but I'm not one of those fortunate ones. So a lot of the time you're just asking your team, like, are we transferring this data somewhere? But the word itself is like layered with meaning from a legal perspective. From a colloquial one, it's literally, am I putting it in my car and driving it down the street? So if you're not very explicit when you're having those conversations about remote access, about viewing data, about just everything and anything, you're going to miss stuff.
That's great. And question for the group, I hear a lot about external transfers. Of course, working at a SaaS company prior to joining TrustArc, you often, do things like look at data processing addendums, standard contractual clauses in customer negotiations. What are some internal versus external data transfers? What are common types? Why are they different? How are they different? What are some considerations?
I mean, again, I think it really depends on how you structure your organization. That's going to make a lot of difference. So I always try to structure in like sort of layering it. So like, is the data incoming or outgoing? Is it incoming from a, this doesn't happen in my current role, but it's happened in the past. Is it incoming from a different subsidiary or a parent company? Is it outgoing to a subsidiary or parent company? Is it going to a client? Is it going to a vendor? Those all come with different, obligations and different requirements. Like, where are these companies? So you really got to start like bucketing things and then analyzing them one by one. It's tedious. I don't want to make anyone think it's fun. I think transfer impact assessments are probably the most boring things we've invented as an industry. And that's saying a lot for an industry that makes records of processing activities. So that's I think bucketing and organizing Excel spreadsheets are really having they're living a resurgence in the last like couple of years.
And then also depending on the kind of transfers you have, the countries are receiving the data. Once you have buckets, you're going to have different contractual arrangements and you're going to maybe apply different transfer mechanisms depending on the relationship. And the agreements that you're going to have to sign as an intergroup level are going to look different to the agreements that you have with your key vendors that are managing most or storing most of your database. But I fully agree with Beatrice. I think that the only way, and it's quite a tough exercise, but try to do those buckets and identify all flows and then identify the obligations and rights depending on each one.
No, I'd love to hear your take. Noelle has, been the chief assurance officer of TrustArc for some time, and she gets to see some of the world's leading companies and their privacy practices. What are the different types of transfer mechanisms that you see across these organizations and TrustArc in terms of internal versus external transfers?
Yeah, well, there's a lot of options, but I think, I think sort of Beatrice and Luca both touched on this, like identifying what a transfer is really critical, because I think to Beatrice's point, people still think of it as like a physical thing when it's really not. But there's a number of transfer mechanisms. We have a slide here. So I just tried to highlight, and we tried to be global in thinking about this. So used a little bit of different terminology, but adequacy is one mechanism. Again, I won't read through all these, but I think we'll talk about most of these in this conversation. But adequacy, that's when one country can assess the regulations of another country to determine if they meet a level of adequacy for protecting that data. So some examples of that, like limited adequacy, is the EU-US data privacy framework. So for companies that self-certify to that framework, they can use adequacy as a transfer mechanism from the EU to the US. And then you have standard contracts, and there's, I saw one stat that said there's something like 22 different versions of standard contractual clauses out of different countries or different regions. I know we're probably most familiar with the EU or the UK IDTA, but China has them, Hong Kong, Brazil. There's the ASEAN model contract clauses, and those are just what they say, really, they're standard contracts. So they're negotiated between parties, and the terms are pre-drafted. And then you have binding corporate rules, which are internal rules that are adopted by companies to align their practices so they can transfer within their companies. And then you have the cross-border rules system, which is a voluntary system where a number of economies have agreed to sign on to a framework, and any companies that certify to that framework can then transfer data within and across those regions. And then you have derogations, which are these sort of specific conditions where you can usually transfer maybe on a one-time basis or under specific scenarios.
Well, that's great. Well, question for you in the group: why are data transfers regulated?
I mean, at least from a European perspective, I mean, the theory and the aim of the GDPR is that because data protection is a fundamental right in Europe and in the UK, is to make sure that the rights that the GDPR is granting to individuals basically follow the data, even if it's processed outside of the European Economic Area. And this is why the GDPR imposes restrictions to the transfer of data to make sure that those warranties, or basically that those rights are warranted during the transit or when they flow to other countries, however, they are access to other countries, because Beatriz is super right. I mean, now everything is about access. But obviously that doesn't mean that the data cannot be transferred. I mean, there are a lot of mechanisms that we see here that can be used to transfer the data. But that is a European aim.
So I would say, you know, I know from the APEC perspective, so that system, the cross-border privacy rule system, came together under APEC, and so the mission of that is to remove barriers to trade and promote economic growth. And so I think there is the European perspective where it's a fundamental right, but I think for other countries as well, there is a economic perspective as well. You know, maybe that's for some smaller countries as well to be able to participate more globally in the economy. And so being, you know, under the APEC system, that's why some of those countries have come together to remove those trade barriers. Of course, there's also the desire to protect the rights of the persons in that region as well.
Yeah, I
But
mean, I think as it often happens, some of these things come into play because bad actors have done bad things, or not necessarily bad actors, but people have taken advantage of looser requirements. And there was a time where moving data to a country that didn't have the same restrictions would open the door to doing things that you didn't necessarily have access to where you were collecting the data. So that's kind of where I think European regulators were groundbreaking in nature, sort of figuring out, well, the world is moving towards not necessarily a cloud-based system, but like a technology-based system that allows for transfers of, you know, we're not moving filing cabinets anymore. So at that point, they were like, okay, well, if it's that easy now to move the data and duplicate it and do all these different things, we need to think about what happens, like if your rights end at the border. It's tricky when you're dealing with a technology, meaning the internet, that doesn't recognize borders.
That's a really good segue into actually one of the questions that was asked. Beatrice, I'd love for you to start since you were on that. One of the folks on here asked, does a data transfer have to be a physical transfer? If someone, for example, in the US is viewing personal data of somebody in the EU, would this be defined as a data transfer?
It would, but I wish it were just like physical. Can you imagine? Like only if you're carting like a filing cabinet across state lines, that would be incredible. I mean, at one time, that's what they were thinking, because at one time that was the only way of moving information. Or you were like, if you think about how the Pentagon Papers became public, somebody literally photocopied them in an office and carted them out of the office and flew with them to New York City, to DC. It's you know, the world is so different now. So yeah, I mean, like any access from any location, and I think there are some things that are clearer than others, and there are some scenarios, like I can come up with some really crazy scenarios, right? Like what if I work for a company and I've made commitments that we will only process data in the US, but I'm traveling to Toronto for work and I open my email, am I violating my agreements? You can come up with some really crazy scenarios, and who knows, maybe one of these days, or maybe Lupe knows, I don't know if there's any case law like that, but I'm sure somebody may. I mean, I can think of at least one guy.
I mean, there are scenarios like this, I agree with you every day. And then the worst is like when you start working on a matter and someone tells you, no, but the data doesn't leave Europe, everything is stored here. And then you realize that one team is in the US, the other one is there, the other one is and they are all accessing everywhere. And exactly, these are all international data transfers. If anyone wants to read, I mean, the European Data Protection Board, in their guidelines in relation to data transfers, they include many of these use cases and examples of like the employee from a company in Poland that suddenly works in the US for a week and carries the laptop. Does it mean that they're doing an international data transfers? In those cases so far, they're taking the view that is part of the same organization, it's not another company, so therefore there's no transfer. But you can have a lot of examples there of, if anyone wants to read about what is a transfer and what is not a transfer, especially because there were also many questions that we had sometimes about US companies without any sort of establishment in Europe, that they were not targeting anyone, for example, in Europe, but we got like European customers buying their products in their US websites. And at some time, I mean, many of these companies, I mean, had the questions whether they were getting data transfers from Europe to them because they were collecting data of European citizens. And that is one of the examples that is clarified there, that is not considered to be a transfer when you're directly collecting the data and from the individual in those cases. But I mean, it's not the most exciting read, but you can jump probably directly to the examples at the end. And yeah, because there are 1 million laboratory use cases in terms of data transfers. And we hear new ones every day.
You know, it's funny, Lupe. You know, you were mentioning the practical aspects. Beatrice had mentioned some hypotheticals. But if you work in SaaS or software contracting for long enough, those hypotheticals will become very real, because somebody will put something incredibly black and white into a contract, and you'll have to walk through all of that stuff and be like, wait, can we actually agree to this black and white concept that seems to be attempting to put up, the internet in a box, when the realities of a modern company are that flows kind of go in all directions across every corner of the globe, and somebody might be traveling and you might have different levels of access and, et cetera.
Conversations, sorry, I was going to say, these are conversations that I have with clients all the time. Because obviously you want contracts to be as clear cut as possible, because that way you don't have interpretation issues. But sometimes, in order to make something clear cut and not make it 174 pages of examples, you end up writing things that are like not necessarily feasible. So it becomes, but for example, I think I've told you guys the story before. In my past life, I dealt with a client who insisted that we needed to include in the DPA that only US citizens could access the data. And I kept pushing back on it, and I was like, and this was 2018, which is relevant. I kept pushing back on it and telling them, this is just not reasonable. We don't check for citizenship when we hire people, as long as they have a right to work. That's not how we do things. And they kept insisting and insisting, and it wasn't a defense contractor. It was a regular company that had no real reason to want this. So at one point they said, okay, well, either we include this language, and this was applicable to all their data, so not just personal data. It could be emails, the contract itself, for example. And at one point they sort of said in the conversation, if we don't include this language, we're going to kill the deal. And I was like, okay, cool. I'm not going to be able to negotiate this contract anymore because I'm not a US citizen. We're going to get to outside counsel because I'm the only lawyer that does this here. And I guess I'll inquire whether or not they're US citizen at the time. And it kind of like snapped them into like focus. And they were like, okay, well, we mean store in the US. And I'm like, okay, that's
different.
That's another story.
It's a request that I can totally help you with. So I think sometimes it's just, you're just on your train track and that's where you're going, and it's not feasible.
Love it. How do you facilitate the transfer of data? What are the common vehicles? And maybe let's look at those from kind of highest focus to least.
I mean, from a European perspective, you have basically 3 ways. I mean, the adequacy, the standard contractual clauses, or the binding corporate rules, or you can apply derogations. Adequacy is like winning the lottery. If you're lucky and the country you are sending the data or is accessing the data from is in the list of the 15 adequacy decisions, from a European perspective, that is like transferring data from Germany to France. So basically, you don't have to apply any transfer mechanisms. It's really easy. derogations are very narrow under the GDPR, and the interpretation from regulators is very narrow. So usually you avoid derogations. And the most popular one is the standard contractual clauses. And standard contractual clauses, I mean, is basically, for those that are not familiar, it's like an standardized, pre-authorized agreement. There are 4 versions, as you have here on the slide. They were published in 2021, and basically they have pros and cons. I mean, the pros is that it's standardized, it cannot be negotiated, it's approved by the European Commission. There's a UK version of it. After Brexit, we had to duplicate everything. So we have the European one and the UK one, but it's like standardized, it cannot be negotiated, so they are quite smooth in terms of like entering it with any other party, because the only thing that you can do is to populate information in the appendixes related to the data transfer, and also pick up a couple of choices regarding jurisdiction and competent authority. And so that makes easy and smooth designing. This is why I think that most companies use it. They incorporate it by reference, for example, in the agreements. It ticks the boxes that if you have a controller to processor relationship, it also has the language that you need to have in the agreement. It ticks the boxes of issues with access of data, for example, by law enforcement in the importing country. However, it has some cons, and we were discussing it the other day when we were discussing or talking about this panel with Beatrice, and I would like to have also your take here, but it's like the main risk is that because they are so easy to sign, they're taking as like something that you cannot negotiate. They're incorporated by reference, as I was saying in the agreement. And you can have 2 scenarios. Either you cannot comply with them, you haven't read them, I mean, and you're taking their 1 million obligations that we always recommend clients, I mean, to understand the SECs and see if they have the procedures in place to be able to comply with them. But that doesn't happen every day. And second, you have inconsistent terms because you have been negotiating the data processing agreement or the MSA or whatever, and you have been having a lot of discussions around liability and audit rights and data breaches and everything. And then you have the standard contractual clauses that no one has reviewed that prevail and are in conflict with those terms. So it's very used, but it's tricky.
I mean, I think I will say the one thing that I will say in the defense of the European approach is, at the very least, there isn't much for you to do. It's very structured, and it's, you know, it is what it is. I'm a big fan of layering transfer mechanisms. So traditionally, the companies I've worked at, I've always pushed, as US companies, I've always pushed to be members of Safe Harbor, Privacy Shield, now the DPS.
Yeah.
Use that as the initial transfer mechanism, because that does afford you more flexibility because it's principle based, and then the DPA essentially controls the specifics. I always add the standard contractual clauses as a secondary layer because God knows how long the adequacy decision will last. Probably not extremely long. It's also, and we could have a whole separate webinar about this, but it's very interesting that we call the DPF an adequacy decision, because it isn't really. It's like a membership-based adequacy decision. Like if you're a member of this framework, then you fall within the adequacy approach. So it's a very odd setup that I find interesting. But it is more straightforward, right? I've personally always dreamed about managing to get standard contractual clauses in place, BCRs in place, but they're so difficult that I've never gotten there. I know Lupe can tell us more about them. For me, I'm a little surprised by the results because, and I don't know if Lupe is going to agree with me, but like I struggle a lot more with South America because of how broken up it is. At least Europe, it's like 27 countries that are all following the same thing, and the UK decided to break away, but kind of follows the same thing because they know what's good for business. So in South America, it's like, well, Argentina is doing this and Brazil is doing that, and there's so much that goes into it, and I tried to keep things very standardized in my DPAs and documentation because we're not a big company. So it's not really feasible for me to have 1,000 different versions of all the things that I have to comply with. But, you know, occasionally you'll work with a very sophisticated large company that will have this like addendum to the DPA, and it's hundreds of pages of standard contractual clauses from all different countries. And I don't even think the standard contractual clauses align amongst themselves. So it's, you know, it's a free for all what actually will happen.
Yeah, and I
Well-
agree with you. I mean, I agree with what you mentioned about South America and Europe, because in the end, I mean, Europe, we have it. I mean, we've been like for years, I mean, having a transfer mechanism. There were standard contractor clauses before GDPR already, and binding corporate rules, they already existed before GDPR. So we're talking about transfer mechanisms that we have had in place for a long, long time in Europe. And then that, okay, there's no much certainty on the sense that we know that standard contractor clauses will get updated at some point and everything, but you know that is something that is uniform, applies to the European Union, and the UK, even after Brexit, is following basically and trying to create addendums to simplify the use of the European mechanism also for transfers outside of the UK. South America, I agree with you, is very complex. I mean, very, very complex. And I know that they have been really like they have tried, I mean, to try to be in a more coordinated way, to have like transfer clauses at a regional level, but it's very difficult to follow. Agree.
I think the US has a lot of similarities to Latin America in that respect, right? It's a lot of fragmentation and fracture. I think there's a bit less focus on the transfer component as opposed to in other regions, but there's a lot of scary similarities there, which is the fragmentation. So let's talk a little bit about other regions. I think we spoke a little bit about Latin America. Any perspectives on Asia and you know, things like, for example, the Chinese SCCs?
I mean, if someone showed me someone who really complies with Chinese law, I would be mad impressed. Because it's like a little bit like fully complying with Russian privacy laws. It's tough if you're not a local company. So personally, we don't operate in China. My old company didn't operate in China. I think it's rough, especially if you're a US company right now, from like a government relations perspective, transferring data to China. I mean, the standard contractual clauses are going to be the least of your problems. There's political implications and regulatory implications that go well beyond that I would be more concerned about. That being said, the law itself, besides the localization requirements, is not enormously different from like other privacy laws. The SCCs are not enormously different. I think the biggest difference between the way China approaches the law and the rest of us do is the role that the government plays in it, which is disproportionate. And I've had several conversations where I've questioned, can you really comply with European laws around transfers if you're transferring data to China? I personally don't think so. So I think it's very tricky. I don't know, Lupe, if you have a different opinion or no.
Agree with you.
What are some practical considerations for these different transfer mechanisms? Are SCCs really the golden ticket?
I mean, to me, and I sort of touched on it before, Lupe sort of flagged how complying with them is not easy. The SCCs are not designed to be adaptable to different business models. They're a very static concept, right? Like right now, we're living in a world where our SCCs right now are from 3 years ago, which is already an insane amount of time for tech. The prior version had been around for 20 years.
Yeah, exactly.
So that alone, the amount of companies that have come and gone, I think it's just, you know, there's obviously operational difficulties, but there are reasons why a DPF approach may not work for you, right? Like maybe you're not able to certify to certain standards. Maybe you don't want to expose yourself to liability towards the FTC. I don't know. Although, like, if you can't comply with the principles of DPF, you can't comply with the specific of the SECs. So I don't know, to me, they're kind of one and the same at some point.
Yeah, I mean, I think that SECs have been taken like by the default transfer mechanisms by many companies. And I see what you were saying earlier, Beatrice, like having the layer approach, I mean, relying on DPF and having SECs just in case something gets challenged, because people have gone through privacy shield, safe harbor, and everything, and it's all a nightmare. So I agree. I mean, if you comply with the data privacy framework, I mean, you should be able to, I mean, I don't see if you can comply with SECs, I don't see why you wouldn't have the DPF certification. But it's true that many companies have taken like the approach of like everything goes with SECs. The GDPR has to be updated and reviewed every 4 years. I mean, it's been reviewed in 2024, and the European Commission has said that they are going to have a look at the SECs. But we'll see. And I was surprised about binding corporate rules, because binding corporate rules, I have done them when I have been in-house, and as outside counsel, I work with clients on BCRs. I mean, now I'm doing some in Europe and in the UK. They give you the legal certainty that you don't have with SECs or DPF or whatever, because you know they're not going to be challenged in principle. They have been updated also recently, so companies that had BCRs now they're in the process of updating them. But usually it's like, once you have them, you have a really robust privacy framework within the organization. But I don't think they are for everyone. I mean, they are really, really intense in terms of like, or demanding in terms of resources to implement them, and also the time. I mean, the time to be able to obtain the approval. I mean, think that BCRs, for those that are not familiar with them, BCRs are approved by all data protection authorities in Europe. And then you need to obtain the UK ones. Now there's a simplified procedure to get the UK ones, but I mean, you start working with one lead data protection authority, and it can take you a couple of years easily until you have a binding corporate rules policy, which is an internal policy explaining how you process data in your group, with the companies acting as a controller when you have controller BCRs, or when you're in a processor business, you can have processor BCRs. So it takes a lot, and then they have to be approved by everyone, and you get comments from everyone, and it can take up to 5 years to get them approved. Once you have them, you open a bottle of champagne. It's amazing. I mean, you have like an amazing program, and then it's really a competitive advantage. If a company shows that they have BCRs, it's great. But I think that it only makes sense to go into this effort and into this process if you are in a really global environment where you have a lot of companies and it's really difficult to manage an intergroup data transfer agreement. Because also BCRs will only cover European transfers. So you will need to have an intergroup agreement to cover your transfers from South America or APAC or whatever. So.
And BCRs, you know, and Lupe, I know you said it, but just for the audience, BCRs are only covering transfers within your organization. So if you're negotiating with a customer, if you're a SaaS company, you can't just say we have BCRs if they're looking for a DPA, for example, with SCCs. So that's something that I would also consider. So that might be a great segue to one of the questions I have here. How do you propose managing data transfers with international orgs that use BCRs? Do you still recommend SCCs for transfer from the EU?
I mean, it depends, because I mean, it depends on what is the role of that organization. If you're dealing, for example, with a group of companies that have processor BCRs, they can rely on the processor BCRs when they are receiving your data. So basically, you don't need to implement another transfer mechanism. All the data that flows to that group of companies would be covered by those BCRs. Another thing is, like, if those companies are using third parties, then basically they are going to have to establish another transfer mechanism there. But in principle, you will not need to have anything else in the agreement. What you need to be very careful is to look what kind of BCRs they have. If they are BCRs for processors, if they are for controllers, I mean, what kind of transfers do they cover? And that in principle should be enough. It is the right BCRs. If not, you will need to go to SECs or DPF or another transfer mechanism.
But if the client, for example, that wasn't in the question, but I'll just poke. But if the client, for example, was outside of the EU, right, themselves, they might still have a requirement for something like
exactly.
Yeah, okay.
Exactly. Yeah, because it will cover only European transfers that the vendor makes. I mean, only transfers of European data the vendor does within their group of companies. So it's very limited. I mean,
So, for the audience, if you were starting out or just building a privacy program, which framework would you use? I mean, I know that we saw a lot of folks using SCCs, but and I know none of the four of us are just starting out in privacy, but if you were, what would you use first? And I'll start with Noelle.
Yeah, I mean, I would probably use DPF I think because DPF allows you to expand your transfers that you're doing without having to do any additional work, right? Once you certify, because it is principles based, if you're applying those principles to new transfers, then it's already included, right? Maybe you have to update what's included on your registration, but that's really it. Whereas like SCCs, if you're expanding the transfers, that means you have to execute another contract or update it, So I think that's maybe an easier one. But of course, if you're not subject to FTC jurisdiction, you can't participate in it, then I would, then I think you'd look at SCCs. But that's probably what I would do.
I mean, I do think that there is an aspect of understanding what kind of business you run. Like if you run a very straightforward, I don't know, non-online retail business kind of situation, and your data flows are very, very limited, and you can comply with the SECs, I think that's fine. I do think as long as you're in tech or similar fields, the SECs will continue to be challenging. I know we've had to do a lot of work to make sure that we align with the requirements. And on top of everything else, they do pose these like challenges around compliance and alignment with MSAs, NDAs, etc. And I don't know, Lupe, but I will ask a live question to Lupe. Maybe she can answer this question for me because it just occurred to me and I never thought of it. But I don't even know if you can be more restrictive than the SECs. So like if your DPA is in conflict by being more flexible, like more restrictive than the SECs, does that also get overwritten because the SECs just take precedence as a whole, which would be an outlandish thing. But now that I think about it, I'm like, maybe I should just defer to the SECs in some contract.
In principle, they will always prevail. So SECs will prevail even if it is more restrictive what the DPA is saying. I mean, but in principle, the SECs are going to prevail. What the European Commission says is like, okay, the DPA data processing agreement or the MSA can add more details. So, for example, in data breaches, the SECs are going to say that you have to notify data breach without undue delay, and then in the agreement you can say within 48 hours and giving this information and whatever. That is not a conflict. But if you have like a conflict between, for example, liability provisions and stuff like that, I mean, SECs in principle are prevailing there.
Lupe, has there been any case law about that? I think that's a really interesting point that Beatrice brings up. I mean, nearly no company that I've ever been at, nor any vendor, only gives out SECs, right? It's always affixed to an Article 28 compliant DPA, right? Whether or not it's for Article 28 anymore, because people use DPAs they might not know it, but it was founded under the basis of GDPR's Article 28, and probably prior to that, really, with the directive. But even in California, they use it. So when somebody has a DPA that covers data processing, further details, et cetera, that is in contradiction, have courts actually made a determination about what happens? Have they actually made that call, or is it just sort of a plain text interpretation?
I mean, it's more interpretation from regulators. I'm not aware of any case law where a court, where this has ended up in court and they have taken a decision. If you go, the European Commission published some Q&A with the new SECs, and they believe that this can be used as a standalone document. I don't know a single company that uses this as a standalone document. I mean, it always goes together with a commercial agreement, with a DPA or something, because also before you need to have a DPA because they didn't have the language of controller to processor agreements. So if you go to the European Commission, I mean, they're very clear. I mean, this has to prevail with over any provision in any commercial agreements, and commercial agreements can only like somehow supplement, but not being in conflict with it. I'm not aware of any case law, but the regulatory point of view and the European Commission point of view is like they will prevail. And usually you have that stipulation in the agreement. So in case of conflict, it's going to prevail.
Interesting. So one of the questions on here was, what are you seeing as common best practices as it relates to SCCs and DPAs? You know, and then it kind of goes on, given how rigid SCCs are, do you require a signature? Or do you just post it on a website? I'll also share, although I'm not a panelist, which is I think that everybody is a little bit split. You see some folks who are using the signature within the actual order form or MSA, especially when it's incorporated by reference. Others are requiring a signature. Some companies are pre-signing them and hosting them online. You can see the majority of larger SaaS companies will post their DPAs online, so you can actually see how they do it. More often than not, I'm finding that either it is a self-contained executable or that it's incorporated by reference into an MSA, in which case it doesn't typically contain a signature. But very curious to see what others have seen on their side as well on the panel.
I have seen all those options, and under European law, it depends on the law of each European member state, whether it is necessary to have a wet signature on the SCCs or whether it's enough with having one pre-signed version and accepted it with clicking. Or so what everyone does is ignoring that national law, basically. I mean, you don't see wet signature on SCCs anymore. This is something from pre-GDPR 10 years ago. And usually what we recommend is to include a provision in the agreement, whether you have it online on the website, or you have a click-through, or you have it pre-signed, or you have like all of those options that you have mentioned, Val, that are all the ones that we see, is to usually include a clause saying that if a regulator requires the SCCs to be signed, basically with wet signature or be signed independently and not incorporated by reference, because in some countries in Europe, incorporation by reference in a contract is not valid, although everyone does it because they are too long. To include a clause saying that the parties, if necessary, because a regulator requires, they will execute a separate the SCC separately and they will sign them. But never happened in the last 10 years. So
that's great. Go on,
from
Beatrice.
my perspective, I had a very odd concern in my career that I've had the last 7 years, which is I was terrified starting in 2017 when I started in privacy that the regulators were going to pull the SCCs from under me and change them. And all of our agreements had these like attachments, and now I would have to go and revisit all of the agreements, and then every client would inevitably have opinions about how to replace them. So I started including them by reference. We do have kind of similar language to what Lupe just said, but not quite exactly. So I might go and change it now. But the other thing that I have done, and maybe Lupe disagrees and tells me that this is terrible practice, but I've also mentioned in my DPAs that we would consider a new version of the SCCs to replace the old one upon publication, because I don't have the energy.
I mean, we've seen that, and many companies are doing that because I mean you don't know when they are going to be changed again, or if they are going to be challenged again, or something. So we've seen it. I mean, it's true that if you update it, if you're incorporating them by reference, and in the end you're going to be updating the agreement, you will need somehow to notify if it's a material change. But I agree, many companies are saying that. I mean, like following the layer approach, saying that the parties abide to use any new SCCs that are published at any moment. I mean, all of that creativity, we see it because everyone has gone through hell updating agreements and everything to update them to new SCCs and whatever. So I think that's fine.
From my perspective, it's like, if that's the thing that you get like, you know, dinged by a regulator on, like you did pretty well. Like if
Yeah.
what you take like issue with is the fact that all you did was add language that said the
Yeah.
SECs will automatically update, like good for you. Like that's an achievement because there are a lot of other things.
Yeah, they're not, I mean, I don't see them challenging that much, and I agree. I mean, that is the less of the problems. I mean, you've done really well if that is the only issue that I pick up. I mean, with the directive, I mean, standard contractor clauses had to be signed, wet signatures, and they had to be filed at authorities, and they had to approve them. And it was like a nightmare. I mean, now we've gone to the other completely opposite side, which is like by reference and trying to make it as flexible as we can. But I mean, I think it's important to have a fallback option in case you suddenly need to sign them to show them to a regulator to have that in the agreement. I agree with that approach.
That's great.
Well,
So
that one thing, Val, sorry.
No.
So I think also there's sometimes there are small companies who, you know, don't have the negotiating power to like use their paper or whatever. And so I think you sort of touched on it, Val, but like, you know, if you are trying to get these SECs, you know, executed, especially with a large corporation and, you know, nobody's even responding to you, you can sometimes look online because they've posted it and pre-signed it. And that may be a way to get them in place if you need to move on, you know, and get that transfer done. So
awesome. So actually, Noelle, perfect time to transition to the next question. What are some recent developments in transfers to consider?
in transfers,
In data transfers, yep.
we touched on a little bit, but you know, the US now has some restrictions, at least to China, so which is a new thing. You know, historically, the US has not had restrictions on data transfer, so that's something to consider. But I think also, I would say with respect to European transfers, and you know, Lupa can jump in, but you know, DPF, SECs, those are always up for review every couple of years or 4 years, whatever the schedule is. And some of the work that was done for DPF, I think it impacted SCCs where you don't have to do transfer impact assessments for the US anymore because of that work. But I think a lot of companies are often looking for like the silver bullet, the thing that's going to make sure you can do the transfers. But like these are also based on the way, you know, political perspectives and the way that countries are navigating those politics. And so I think it can be hard to say like you do this one thing and you're set for forever. Like you sort of have to be on your toes and keep track of what's happening globally and what are the mechanisms that are out there.
And did we want to also jump in and talk a little bit more about the recent developments with APEC that I'd heard about?
Yeah. So with the Global CBPR Forum, which was created in 2022, if you're familiar with APEC, I'll talk about that as well. So the APEC CBPR system, again, is the system where several economies have joined on and agreed to an international privacy framework. And so the Global CBPR Forum is based on that. However, because the other one is under APEC, it is limited to countries in the Asia Pacific region who are part of member economies of APEC. And there were countries that were starting to acknowledge the CBPRs as adequate. So Bermuda did that. They recognized it as an adequate mechanism for transfer out of Bermuda. The Dubai International Financial Center, which is an economy out of Dubai, did as well. And so the idea was to expand it beyond the Asia Pacific so that other countries could sign on to this. Because as we've sort of mentioned, right, there's 22 different versions of SCCs. There's over 80 countries that have an adequacy mechanism. There's, you know, you have to do so much if you're transferring data to all these regions. And so the Global CBPR Forum idea is that if, you know, more countries sign on, there is a simplified mechanism to remove all that work with data transfers. So some of the members, they're listed here on the screen here. You can see Australia, Canada, Chinese Taipei, Japan, South Korea, Mexico, Philippines, Singapore, USA. But the newest member is an associate member, which is the United Kingdom. So they signed on last year because they, they've been participating in the system as well. And so right now, the requirements for both of these, for APEC and Global, align, but they will diverge at some point, right? They will, as most privacy regulations do, this Privacy Framework 2 will be modernized and reviewed, and possibly more countries will join on to that. So the way that a company can use this as a mechanism is to get certified. And so what you do is you look at the privacy framework, make sure you're complying with those. You work with an accountability agent like TrustArc to certify to that framework. And then you can participate in the system and transfer data within those different regions. And there's two different types of certification. There's an enterprise-wide one which is called the CBPR, Cross-Border Privacy Rules Certification. And then there's one specific for processor activities, which is called the Privacy Recognition for Processors. And so if you're just looking to certify, maybe that's primarily what your data transfers are, it sort of flags to all the other companies that do participate as well that you're meeting a certain standard in your privacy or in your processing practices. And so the global CBPR certification is going to become available probably in the next month or so, we'll say summer. And so companies can start to participate. And I anticipate we'll see an expansion of the global CBPR forum to other countries. I was recently at their workshop in Tokyo a couple of months ago, and there's about 24 different countries represented there, who are expressing interest in joining from all different regions, from the Middle East, from Latin America, other parts of Asia, Europe, Germany was there as well. So there's a number of countries expressing interest, and hopefully it'll continue to expand.
Just as a sort of editorial there, for folks who are working in larger global businesses, I was a big fan. I am a big fan of this idea of DPF plus APEC. It's the closest thing you're going to get to a follow the sun transfer mechanism model. The world is full of different international transfer laws, and it at least moves you closer to having some level of unification that can be helpful from a both external perspective when you're talking to clients who need some assurances around your ability to transfer data lawfully or process data lawfully in the APAC regions and the Latin America regions, as well as in Europe with DPF. So it's just one more thing to consider about as a practical matter. I wanted to thank everybody so much for joining, as well as our panelists for their wonderful contributions.